And off the top tonight, the historic criminal trial of an American president continues. Former President Donald Trump was back in Manhattan this week facing felony charges for a hush money scheme to cover up a sex scandal.
I'm sitting in a courthouse all day long listening to this stuff. And everybody knows, as far as everybody is concerned, if you read the great legal scholars and experts, everybody said this is a trial that is nonsense. It should have never been brought. That's showing loud and clear. But you have a judge who's totally conflicted, totally, absolutely conflicted, that he's rushing this case through.
Former White House Communications Director Hope Hicks took the stand on Friday. Prosecutors say Hicks was a part of the meeting to craft that catch and kill scheme between Trump and the National Enquirer. The jury also heard from attorney Keith Davidson this week, the man who negotiated the hush money payments to both Stormy Daniels and former Playboy model Karen McDougal. Remember, part of prosecutors' theory here is that the hush money payments were made to influence the outcome of the 2016 election. But instead of being listed as business records and campaign contributions, they were hidden as legal fees. Now, Davidson's testimony is central to the case. He testified that Stormy Daniels' story of a sexual encounter with Trump back in the early 2000s became much more marketable in October 2016 after the now infamous Access Hollywood tape was released. Prosecutors say the campaign was particularly worried about stories involving women coming out after that tape was released. So that builds a stronger connection between the deal to pay off Daniels that Davidson secured just weeks before the election and the campaign wanting to avoid negative stories. But Davidson only dealt with Trump's former fixer, Michael Cohen. And Cohen is an admitted liar and may be a big problem for the prosecution.
A central theme is emerging in the defense here, which is this. Michael Cohen, whatever he was doing, he was off the reservation here. He was acting on his own. He was doing things that he was not running by Donald Trump. He was doing things that Donald Trump did not know about and did not approve.
Michael Cohen is a problem for the prosecution, not only because he's an admitted liar, but also because they have to prove that Trump knowingly broke the law here, that he had criminal intent. What is criminal intent? Well, it's not always so clear, and it depends on the crime that's charged. Even the Supreme Court struggles with the concept sometimes.
Nobody knows what corrupt intent means. We've been around that tree
we will
twice
probably
already.
find out.
And maybe it means that he knows that he was doing wrong.
Justice Gorsuch was probing the DOJ's lawyer there in the Trump immunity argument. He was talking about corrupt intent. That's a branch of criminal intent. But the statute Trump is charged with in New York is the falsifying business records violation, requiring people to prove his intent to defraud. And there's no penal definition of intent to defraud, but looking at how New York courts have interpreted it, it means with the intention to deceive another person or to frustrate the state's power to carry out its own laws. The bottom line here is that prosecutors are going to have to prove what was in Trump's mind at the time the crimes were allegedly committed. And that's no small feat. Also this week, Judge Juan Manuel Marchand, who's overseeing the hush money trial, ruled that Trump violated a gag order 9 times, fining him a total of $9,000. Marchand also warned Trump that if he continues to flout the court's order, he's willing to put the former president in jail. And we can confirm the Secret Service is currently discussing plans in case that happens.
The best case scenario, if incarceration would be ordered, would be home confinement, because he could go to Mar-a-Lago or he could go to Trump Tower and just stay there and not have to leave. And that would make things incredibly easy on the Secret Service. Because the other things that need to be considered if he is in a facility is, does he become a person who's put essentially involuntarily into isolation because his meals would all have to be brought there? Because it wouldn't really be practical to bring the president to a cafeteria inside a correctional facility.
Now, Marchand appeared to be frustrated that he was limited to a maximum fine of $1,000 per violation, suggesting that a fine that amount wouldn't really have the desired effect on someone who could pay it easily. Marchand also ordered Trump to remove the posts that were violating the gag order, and Trump did so. Now Marchand is considering 4 more possible violations of the same gag order. One of those 4 possible violations, a monologue that Trump delivered to the press outside the courtroom, calling Michael Cohen a liar. The gag order prohibits Trump from making public comments about witnesses. Cohen will likely be a star witness. Trump's attorney, Todd Blanche, tried to argue that Cohen shouldn't be covered by the gag order and referred to several of Cohen's social media posts, essentially goading Trump to respond, like this one right here. And as of this taping, Marchand has not yet ruled on those 4 potential violations. And speaking of Trump's lawyers, a law firm that has represented the former president for years is trying to cut ties with him. The firm asked a federal magistrate judge to withdraw from defending Trump in a pregnancy discrimination suit, citing, quote, irreparable breakdown in the attorney-client relationship. Now, the public filing didn't give us any details as to what exactly that means. They wanted to brief the judge in private, but instead of that, the judge just denied their request. Meantime, it's May, which means we're less than a month away from Hunter Biden's federal criminal trial over gun charges. That's set to begin June 3rd in Delaware. But this week, Hunter went on the offense. Hunter's lawyer sent a demand letter to Fox News claiming that the network used sexually explicit images of the president's son that belong to Hunter and may have run afoul of state revenge porn laws. Also this week, the former FBI informant who is charged with making up a bribery scheme involving President Joe Biden and his family lost his bid to get out of jail while he awaits his criminal trial. The default in our criminal system is to release people who have been charged with a crime before their trial. But a federal appeals court in California ruled that Alexander Smirnoff is a flight risk and that no conditions of release would reasonably assure that he shows up in court for his trial. Smirnoff is accused of lying to the FBI that executives from the Ukrainian energy company Burisma had paid President Biden and Hunter millions of dollars back in 2015. Meantime, outside the Trump-Biden world, the Federal Trade Commission issued a final rule banning non-compete agreements. Non-competes are contract terms that prevent workers from going to a competing employer within a certain area or time period after their employment ends. And the FTC says the rule promotes competition and protects the fundamental freedom of workers to retain jobs. But less than 24 hours after that rule was announced, it landed in the courts. Multiple lawsuits have been filed challenging the rule, including one by the U.S. Chamber of Commerce. They're arguing that the FTC is out over their skis here and doesn't actually have the authority from Congress to ban non-competes. The rule isn't set to take effect until later this year, but a judge could put a much longer pause on things while the litigation plays out. This week, the Virginia-based federal appeals court said state health insurance plans must provide coverage for gender-affirming care in North Carolina and West Virginia. A divided court ruled 8-6 that North Carolina's state employees' health plan and West Virginia's Medicaid has to provide gender-affirming care, including surgeries. And the decision is hailed by transgender rights advocates and comes just weeks after the Supreme Court allowed Idaho to enforce its ban on gender-affirming care for transgender youth, while lawsuits challenging that law proceed in the courts. Also this week, hundreds of protesters across the country who took to college campuses to express their anger over the Biden administration's approach to Israel and Palestine. They're demanding colleges and universities divest from Israel. From Tulane University in Louisiana to Columbia in Manhattan, students and outsiders were arrested and hauled into courts on various charges, from trespass to criminal mischief to burglary. We'll take a closer look at the laws at play here with our guest coming up after the break. And in our neck of the woods, Baltimore's former top prosecutor Marilyn Mosby is taking to national news outlets to try to avoid jail time. She's facing up to 40 years in prison after a federal jury convicted her in 2 separate trials, one for perjury, the other for mortgage fraud. Now she's awaiting sentencing, and she says it's a political prosecution and she was targeted.
Know that I've done absolutely nothing wrong, nothing criminal, and to be separated from my children for 40 years as a result of withdrawing $90,000 of my own money, it just makes absolutely no sense. It's illogical.
Host Joy Reid suggested that Mosby was only prosecuted after and perhaps because of her decision to prosecute the police officers who killed Freddie Gray, the 25-year-old black man killed in April 2015 in Baltimore. None of the 6 officers involved were convicted, and Mosby's criminal sentencing is now set for May 23rd. Also in Virginia, a federal judge declared a mistrial on Thursday after an 8-member jury deadlocked in the civil trial of a military contractor accused of abusing detainees at the Abu Ghraib prison in Iraq 20 years ago. The jury deliberated for 8 days and was unable to ultimately reach a decision. The former detainees and the survivors who sued the contractor can ask for a second trial if they so choose. And also in Virginia this week, an update in the missing middle litigation in Arlington. A group of residents sued the county, saying that the county didn't go through the proper procedures to implement this missing middle zoning. But during discovery, which is where both sides exchange information, the county subpoenaed Dan Creedon, who's a potential witness in the case. Creedon founded Neighbors for Neighborhoods. That's a group that helps fund the lawsuit against the county board. And its GoFundMe page now has over $75,000 from over 450 separate donations. Some of them are anonymous, but some are not. And the county subpoenaed Creedon after he was listed as a potential witness for the residents. The county says they want to know who's behind the funding and who's really calling the shots here.
It's very personal. We're all private about our families. We don't want them bothered or harassed. And in today's era of social media harassment, we see all the time in the news these things. This is a very dangerous step for the county to be taking.
Lawyers for the county tell Fox 5 the court and the public is entitled to know what forces and whose interests did and now control the litigation, plain and simple. The county's not targeting far-flung information about its citizens participating in the political process.